Aloha kako, Keeamoku Kapu of Lahaina once again. And the question before us is quiet titles. So where did quiet titles basically come from? To us, to me, knowing and understanding the jurisdiction of Ko Hawaii Pai Aina and all these things that had occurred in the past, quiet titles in Hawaii is a fictitious thing because, as I've mentioned before, once the names are placed in the indices awards made by the Board of Commissions to quiet land titles, the titles are quieted. So where is this foreign law all of a sudden comes in to say that they found a remedy to quiet title from Native Hawaiians that claiming that they have abandoned their rights to their property, so all of a sudden a foreigner can arbitrarily come into these lands and squat in these properties for X amount of years, only to finally go in front of the Second Circuit Court to file a complaint on a kupuna of the original inhabitants and the heirs of these lands to quiet title and adverse those properties arbitrarily, all because they feel that they have the rights to it because people or Kuleanas that once existed in the area abandoned the rights to their property. So where that comes from, again, one better solution for everybody that these primers that came out from the University of the Richardson School for Law, and it was put together by a bunch of attorneys from Kahuliao Center for Excellence in the Native Hawaiian Law. So these primers are offered free for everyone out there, and you can go online and you can punch in this, and normally it's provided through the Office of Hawaiian Affairs. And the primer is Eoni Pa'aika Ike Kuleiwi, the legal primer for quiet title and partition lands in Hawaii. And this one was put together by a few attorneys, Stephanie Chen with Kainui Smith, Maria Sukayama, and Lisa Higa. So all the information that they provided inside it kind of gives you a basis as pertaining to if all of a sudden you was to read in a public newspaper and found that somebody is challenging the validity of your claim and filing a quiet title, this would be the start. And it comes with a CD-ROM where you can download. But this, I would say that if a lot of families are having issues as pertaining to what to do, what kind of attorneys to look for, first you might want to study the facts as pertaining to what the derivative is all about when it comes to quiet title actions in court. This is the best primer I feel that would get families started. Secondly, don't even wait. Once you get a notice in a public notice newspaper saying that somebody challenging your kupuna who died in 18 something, then I always try to get a lot of families to understand the most importance as pertaining to who you are as an individual, and it's based on your identity. So when I talk about identity, is normally when you go in the courts, their attorney's job is really to prove you're not the person you claim to be by chastising your validity of claim, because a lot of us before, we didn't know how to handle these court cases when we went inside, thinking that the judge would be non-biased, and when you go inside there, the judge says, okay, you have anything for us? And if you don't have anything, normally the judge says, okay, judgment to the plaintiff, and that's done. So what I try to do is try to help families out there on getting their palapala, the papers put together, by putting together an affidavit. And the affidavit would be really simple. Yeah, I so-and-so am of lawful age. My name is Keeamoku Kapu. I was born in April so-and-so. Yeah. And the first affidavit, exhibit would be my birth certificate. Your father, his birth certificate. Your grandparents, their birth or death certificate, or even marriage certificate. Any document from the health department, the conveyance, the state archives, that talks about there's an unbroken chain of descent from you, using health records, marriage certificates, death records, probates is really important to see where the families were situated. Sometimes when you look in a probate, you find out that the family still had interest of those properties back in the 50s. And you can take it further back by looking into like census records. Some of the stuff that I have inside here is like from the archives in Oahu, and that's right next to in the same compounds of Liliuokalani Palace. That's right on the backside of the palace. Between the palace and the legislative building, the archive center is there. And you can pull up census reports, 1878 census reports that show that your kupuna actually still lived in the area of what the quiet title is all about. So what you need to do is put together an affidavit that shows that you have a direct descent of that kupuna who was awarded property from the time of the Mahele and the Indices Awards. Once you do that, that becomes your valid claim of an undivided interest to help you in pursuit of finding clarity against somebody, a third-party interloper foreigner that literally doesn't understand the rules, and this would be enough to challenge the validity of any claim, to say that these heirs still own an undivided interest if none of the heirs within theirs. Normally when you look at one census, the census will automatically tell you, okay, there wasn't only one person on the property, there was a whole bunch of people that lived in the property, yeah. So how this works is, okay, this is mom and dad and all the kids, and when they passed away, the kids inherited the interest. They got married, they had kids, those kids also inherited an undivided interest. If say maybe 3 of them sold and the rest never sell, then the family still have a valid undivided interest. It depends on who probably sold the property and who didn't sell the property. But then that's another question when it comes to the legitimacies of transferring title under the rules that was set under the Board of Commissions for Quiet Land title. So that's another question. It's pertaining to whether or not the government consented the transfer of the title. So there's a lot to talk about when you're talking about quiet title. But for me, my whole thing is to help families out there, especially families that are going through it right now at this point, that somebody is challenging their validity of claim to a quiet title adverse possession. This is the first step to go. Once you get this far, then that's your right to challenge. And your right to stand on the foundation of what was provided by the Kingdom of Hawaii, yeah, on how they were able to, as a constitutional monarchy, how were they able to protect these lands in the Kingdom of Hawaii from foreign invasion. We're being invaded illegally, so I try to get out there to the general populace of our Kanaka Maoli out there to say that we lack the ability of understanding these foreign laws. So what it takes to solidify our claims is we need to put a document like this together that challenges these foreign entities pertaining to who we are and what was provided for us, yeah, through an allodial title. Passed down from one generation to the next generation to the next generation by blood. And that is enough to say that we have a valid claim to challenge. Once those things happen, that you get the notice, they have to print 3 notices in the newspaper. And after the 3rd notice, they say, okay, this is a date that you would have to show up to appear in court. Once you appear in court, then the judge says, okay, calling on the complaint of so-and-so, complaint number of the heirs of Kapu. Then the judge does the announcement and tell whoever is here for the filing of the complaint of the Kapu, want to please stand. And the sad part that I see in a lot of cases when these things happen, there is hardly anybody that makes the stand because nobody understands the rules of the game when it comes to even the public notice. A lot of our Kanaka, they rather read the sports page instead of reading the public notices on the lawful things that are placed in the newspaper. If they don't get a heads up and they don't know about it and they don't show up in court, then normally the judge says, okay, judgment to the plaintiff. There's nobody that appeared. Let the court reflect that nobody appeared for this court case number on the complaint. It's done. But then if you are there, the judge says, okay, approach the bench, put your name down on the pala and your contact. Then the attorney is required to send you the complaint. And it's a complaint to quiet title. So once he sends you the complaint, you have 20 days to respond. If you don't respond within the 20 days and the court date is set, and you go back to court to answer to the complaint that was provided for you by their attorney. And if you don't have nothing to show them and you're begging for the mercy of the court to help you, the court's hands are tied, and normally they would say judgment to the plaintiff. But if you have your pala set and ready to go, this is the combatant to file with their complaint to say that, okay, I am challenging your complaint with my affidavit. And once you do that, then automatically the judge, and I've seen this many times before, will say, okay, you have a valid claim, let's proceed with the trial. Okay? So now what it does, it makes the attorneys a little bit more worried, because now they have to prove that you're not the person you claim to be by the information that you provided from documents from the health department, the archive, the Bureau of Conveyance. Their job is to scrutinize, to say that, first of all, like it happened to me, first of all, none of these documents that Mr. Kapu provided is even certified. Yeah, so they try to throw a whole bunch of wrenches inside there. So, which means when you get these documents from the health department, from the courthouses like probates, it only costs you $2 to get it certified. That way you can put it in your complaint file. And anything that you receive anywhere from like the Bureau of Conveyance, also get it certified. That way you can get past the madness. But that's only a technicality is what he's trying to throw, saying that all documents should be certified in front of the court. But normally it only depends on the court, yeah, or the judge, on whether or not it should. Because when you're talking about birth certificates and death certificates, there are docket numbers on it, yeah? The Department of Health, all these numbers on top. At the same time, I might want to warn everybody that when you submit these kind of documents, if there is Social Security numbers, get rid of all, black out all the numbers all except for the 4 last numbers. Yeah, because Social Security, there's identity theft out there, so you don't want to be submitting information into the Bureau of Conveyance, which becomes public, where somebody can actually pull that document, look at a lot of, especially your kupuna, if your kupuna had, grandparents had Social Security numbers written down, you might want to X that out. Yeah. So this, you can also take it a step further. Once you do your affidavit, you get it notarized, public notary. Yeah, this one I went to the bank to get the notary. Regular public notary is good. Oh, this is the royal patents. Then you're good to go. Once you get public notary, you're good to go. If you want to go a step further, I went a step further and I recorded it in a land court and I got a docket number. So this more solidified to say that this is placed in the Bureau of Conveyance for all the public to see. And if the attorneys want the information or more information, they can go into Bureau of Conveyance and they can buy this. It's not free. You gotta buy it. Okay? So this is the way that I feel I can help out there with a lot of families that really are mesmerized as pertaining to what they need to do. And hopefully this will be a redemption for a lot of families out there that is watching this for myself. Hui Aloha, Aina. And yeah, that's it, basically. So good luck out there. And if there is any more inquiries out there, hey, let the organization know, then we can kind of fill the void. Mahalo.